Swayam Prabha. Digital India. Educated India.
A very warm welcome in the second module of week 7 of the course Roadmap for Patent Creation, titled When to Publish and When to Patent. Now this is the query to many people, that when I should file a patent and when I should publish a paper. Previously, means scenario a few years back, a decade back, what we can say, scenario was means publish or perish, that was the scenario. But now the scenario is that patent, then publish, otherwise perish, that was the scenario. Just thing is there. Now, so the important is that publications and patent filing both are very important, right? In the academic institutes, mostly the scenario is that importance is given to publications. So when we will deal with this when to publish and when to patent, we will check 5 scenarios: that research and a student, how it exactly it is happening; research and scientist, it's a more close what we can say scenario; then any project which is going on in the college level, and then the students who are working on that project, and the competitions. So related to that thing we will see. Then MSME, whether they will how they are related to patent process. So we will just see a aspect in a small way, that MSMEs and publication and what we can say, because they are more in the commercialization phase, not in publication mode. Mostly they are in a commercialization mode. So there we have to be very careful. So we will see that aspect. And the fifth aspects I am just giving it to professionals like doctors, or what we can say the engineers which are involved in creating new products or processes, how they should deal with that. Okay. So we will see one by one these scenarios. We have seen first to file rule, right? What is the thing in first to file? It is that everyone, means if you want to get a patent, it is important that you should file patent before publication. That is, we have seen. And we know now that novelty aspect is very, very important when we are considering a patent. Then in the tool we have already seen confidentiality aspect, again most important. Means if you maintain confidentiality, then it is possible for you to maintain novelty, which is one of the important criterion for patent. Okay. So here how you will strategize your research. Okay. So we will see first scenario. That first scenario is that research students, especially research scholars who are working in an academic institute. What is the pressure on them? Generally the pressure is that 2 publications or 3 publications, something like number is there, and there is a, without that publication students will not get degree. That is a rule. That is most of the academic institutes follow that thing. This is a very good rule, considering the what we can say the get best output. Means once you have a that particular what we can say a benchmark is there, students will generally follow that thing. And if that particular ranking means okay, this rank journal, all this means there are different opinions about that, whether you should publish in that particular journal, that ranking and all that thing. We will not go in a detail of that thing, but we have to just concentrate on that publication and the patent filing. And we know that without patent filing you should not publish, that is a must, we know that thing. Now how you should plan that activity, because that is a confusion in every research scholar's mind, how I can have a patent also and a publication also. So you have to plan the activity. So how you are going to plan? So we have now that 3 dedicated modules, we have just given how you are going to plan a research. So we have given you so many tools, so many ideas, that from zero, that is nothing, you are just starting your research, to your completion of research, how you are going to plan your research to get a patent, right? We have already given you that idea. Now, what are the important steps in the research process in academic institute? Generally, there are what we can say the seminars are there, right? Obviously, these are the assessment is done every yearly. General picture in the universities or academic institutes in IITs, which is followed, is that every year you have to give that progress seminar. The name will be different, but some activity like that is always there. So generally student asks the question, if I will say or share my research in progress seminar, whether it will go into the public domain, whether I am losing novelty, before that I have to publish or not. No, there is no necessity of that thing. If you are doing very important, what we can say, if you are planning for a patent, you should plan for the patent. I will not give you the option when you are doing a research, and if it is applied research, you should file a patent, you should aim for a patent. So in that case, what you can do means, generally you can follow the thing is that when you are discussing the research, obviously that group who is there, to whom you are discussing or you are presenting the thing, when it is that progress level, generally it is a closed group. So if it is in a closed group, you need not to worry. But if you have that doubt, you can just insist and you can just make the process in such a way that whosoever is attending that thing, you can restrict on the attendance. That is the first thing. The second thing is that if you are not able to do that thing, the second way is that you can just make sure some in writing that if anybody is attending that particular thing, you have to keep the things confidential. Whatever the things are shared in that meetings, in that presentation, it should be confidential. That must be mentioned. Rather, generally means the academic institute only, as a policy only, they will follow that confidentiality. Generally that thing is followed, but if it is not followed, then we have to insist on that thing. As a student, you should insist on that thing. So as a process means 3 years, if PhD is taking 3 years or 4 years, you will have that 4 sessions kind of thing, or maybe intermittently you will have a discussion, but that will be a closed group. So I will not suggest in that closed group, already your research is evolving. Obviously you may not have anything to patent at that time. So don't worry about that thing. You just make a processes in such a way that closed group will take care of not losing the confidentiality, or they will not share your invention with anybody. You can implement that processes. Now whenever you are thinking of a publication, that stage of, you are now in that stage, okay, I want to publish now. We know that any publication, when you communicate, generally publication in a very good paper, it takes 1 year at least. So that long time span is there, that we know, and till that publication, your paper is still, what we can say, in a closed group. So if you are communicating with a publisher, you are now ready for a publication. At that time only, if you are, what we can say, before that, if you do the provisional filing, wonderful thing. If you are not sure at that time whether we should file provisional or not, if it is only literature review and all that thing, you need not to worry. You can just publish on the literature review part, right? But after that next stage, when you think of a second paper, because first paper will be like literature review based, some analysis and all kind of thing, that is in the process. And maybe the second paper, when you are thinking that there might be something which is having a potential, possibility is there. So when you are communicating about that particular thing, maybe after 2 years of your research or 2.5 years of a research, I will suggest that before communication, better you file a provisional. That will be the best, because generally first paper is on literature review, need not to worry about that thing. But that paper, after that 2.5 years or 2 years, it may be having something potential. So just analyze that thing, apply all tools, apply that whatever the knowledge which you have gained through this course, and check whether there is any potential, right? If you are not sure, you discuss with your supervisor, right? Discuss with a very, what we can say, the person who is very, if you have a IP system, that professors are there who are helping you, that IP system is there, your what we can say IPR cell is there, better take appointment and discuss with them. They will help you, because they are expert now, they are the people who are continuously working in that particular area. So take appointment of the professor who is that in charge of IPR cell, or staff members who are working in that area there, you just take a appointment and discuss with them. They will help you that whether you should file provisional now or not and all that thing. But you also, after going through this, you will perfectly able to judge that thing. So the thing is that before communication, you just file a provisional. If it is missed before communication, if you due to some pressure and all that thing, if you missed, we know that it is taking 9 months time, 8 months time or a year time. Better when that process is, review process is going on, once you are filing, means if you have communicated with a publisher, just thoroughly check that thing and file a provisional. We know that timeline is there, that timeline, within that you can file a provisional. So student can do that thing. Then the next thing is that the possibility is that you have done during that the process, your publication and patent, it will go. So how it will happen, that the same thing which is going in a research publication, already you have a filed patent for that thing. So you will have one patent, one publication. It's a big gain for you, right? So and then if it is a, what we can say, the further when you will develop that particular patent and all the thing, obviously you should commercialize that thing, but at least now you just think in this way. That is the first step you have done. When there is a increment, means some your progress is there, and generally what happen at the end of 3rd year or 4th year, you will have substantial thing to patent, definitely. So at that time you should again visit, follow all the thing, check patent, follow that patentability tool, IP identification tool, do that thing and just check what about the second. When you are going for that 3rd research paper, you think of a second patent. If you plan it in that way, definitely you will have a 2 patents, 3 publication, 3-year timeline, and you will have perfect output for your research. Means if your applied research is there, patent will be there. If your research is a fundamental research, obviously you will not think of a patent. Okay, that is the case. Further, what happen after that? Suppose you have done that work and then thesis is ready, and a few things are still, means after thesis submission also we know that we are still in the mode, means there are so much work we have done that is in the thesis, and you have to publish that thing. So again you just check out if there is anything, extract that thing. If you are thinking of further work, whatever is there, you just you have to, what we can say, keep identify that work and you have to file patent. But I guess in a 3 years time, 2 patent, good patents will be a, what we can say, ideal situation will be there. Now the thing is that you will say my thesis I have to submit, then that electronic copy I have to give in the library, how can I keep the confidentiality? Here you can do one thing, write a letter clearly, you say that this thesis should be kept confidential, kindly don't make it available publicly, and still the process of patent filing is going on, you just mention that thing. So they should know why you want to keep it confidential. So you just mention that thing, take your supervisor's signature, if required anybody else, means your dean, higher authorities are there who are involved, means if necessary you just follow that thing, consult with supervisor, and then you give it to a library. So the library means they will not make your thesis available in the public domain. You have to do that activity so that your work will be, now the confidentiality is maintained. That is a important thing is there. Again, when defense is scheduled, right, and still if you have not filed a patent and you have now to take a, what we can say, caution, here again you have to take a caution that when you are still in that patent mode, it is not still filed, again when you are organizing your defense, obviously make sure that you will take a signature on keeping that confidentiality. That because institute do that thing, when your thesis goes for the examination, first thing institute or a university do is that they ask for a writing from the examiner, that reviewer, to sign a confidentiality document. So means that document is signed, then only your thesis is communicated to reviewer, otherwise it is not communicated. If institute is taking that caution, you have to also take a caution that if you are still in the process, communicate it clearly with the library, communicate when your defense is organized, so that you can maintain that confidentiality thing. Though that learned society, that option is there, we will not take a chance for that thing. So I guess now you have that pretty well idea when to publish and how to file a patent, right. So, as a research student, you have to take a caution in that all stages, your progress seminars, your defense, your thesis when it goes for the review, then your thesis. After that you have to deposit in the library. At that time what you have to do, and in whole process obviously you should be very diligent. You should communicate with the IP attorney or the professor who in charge of the institute, who are taking care of that IP system in your institute. And if that things are not available, you yourself should push for that thing, and you should take the steps to protect your whatever your research is there. So, this is with the research students. Obviously, if you are a research institute and scientists who are working in that area, big research organizations are working. Obviously, here also all research scientists means they have to take this caution. You are the people who are continuously working on that particular project, and for this it is like you are working for years together in that domain. So, obviously, so many patents are possible from your work. So, before any publication, request you that you just check whether there is a possibility of patent, use the learnings from this course, use the tools, identify potential patent and file a patent, then only you communicate. And if you have communicate immediately, still when your paper is in the review process, make sure that patent will be filed. So, this is about research. First case, that is a research scholars, second that a research and a scientists who are working in a research organization, because you are the people who are working continuously in the research, means your area is like you are like a R&D people. So, you are like continuously you are in the process of creating something new, and it is your diligent, what we can say, your diligent mind should determine and identify that potential IP. So, this is the second case. Third thing is that engineering college student or science college student, what they are doing, they have a project. Sometimes they in one of the semester they have to do a project. If they are doing a very good project, obviously it is expected everyone should do a good project. But if you are sure about, okay, my project is novel, take a help of your teacher and think about what is a possibility through college for filing a patent, right. So, you have to take a help of your teacher and find out, if I do something, how I can, and here again this course will help you to self assess the thing. You will not require any IP expert for that thing, self assess the thing, and once you are sure about that thing, then you take help of a expert, right. And for that you can just involve what we can say authorities from the college, and then you can move ahead. If authorities of college are not interested, you yourself can do all this activity, you yourself can file provisional. Already through the course you know how to do all the analysis for identification of potential IP, you can do that thing, and after provisional filing you can take help of some attorney or patent expert for filing a patent. The other most important thing is, if you are, it's very tricky, if you are participating in any competitions, right, there are competitions, they will give you prizes like 50,000, 1 lakh, 25 lakh, that kind of competitions are there. If you are participating in that competitions and if you are solving some problem, remember, you are giving solution to the problem. If you are doing that thing, if you have that solution for that thing, first file provisional and then participate in that exhibition wherever you are sharing your solution to that particular problem, because you are offering a solution for a problem, and here you are giving your IP easily to somebody else. So, be cautious there. Okay, so, this is a third case. Next thing is the MSMEs and the patent process. How is there any publication and filing issue is there? The possibility is that MSMEs, to promote their product, they will not do research publication, but they may do publication related to their product before filing patent. That is possible, not research publication. So, if you on your site, website or in any exhibition, that is a possibility for marketing, because MSME, they are working hard, they are creating their product or processes, and they want obviously they want to market that thing. So, in that complete flow of thinking of a marketing, they may miss to file a patent and to identify the importance of your IP. So here the suggestion is that when your product is almost ready, or when you are sure about, okay, now we will enter into the marketing phase, before that, before going into the public domain, make sure that at least you will file provisional patent. Take help of this learnings from this course and file that provisional patent, and then enter into that marketing phase. Okay. That is a fourth case. Now the last case, doctors or engineers who are working in a particular area. Now we know that doctors are not able to do that surgical methods and all that thing that are not patentable, but instruments, diagnostic tools, you are the people, right, who are handling that instrument continuously. You are the people who probability is that you know that diagnostics tool, whether it is how it is working and all that thing, and in the process you may think of something and you may create something which will be a very good diagnostic tool, which may be a very good instrument to do particular surgery, particular what we can say the activity which is related to that particular process in your that service, whatever is there. So in that case it is your duty, because nobody will understand what exactly you are doing, but you, because of your what we can say practice in that particular domain, you can identify. If you have gone through this course, you will appreciate, oh, I have done something, it's something new, nobody is practicing this thing, or this kind of difference means this, if that instrument is available, this will be helpful to so many people. If that kind of understanding is there, you can think of, or you can take help of an expert, IP expert, and can think of a filing of a patent on it. And again provisional filing, and then you can just discuss with anybody, or you can have a non-disclosure. Generally it is all these things, non-disclosure, all these things is not required, but you should think, and then you can think of filing that patent related to that particular diagnostic related thing, particular surgery related any instrument, particular what we can say the disease identification related, if anything is there, you can just think of that thing, right. So here what we have seen is that we were means that confusion when to file a patent and when to make it available into public domain. It may be in the form of research publication, it may be in the form of a marketing manual, it may be in the form of a actual practice. So here the important thing is that if you are coming into the market or any kind of publication is there, filing of patent is important. So first to file is very important, and then you are thinking of the what we can say publication. So these 5 scenarios, like a research scholar in the academic institutes, that research institutes and scientists, so that is scientists in the research institutes, then the students who are working on project in college, then MSMEs and their what we can say their activities related to any invention, and doctors and other professionals, possibility of what we can say they are making that patent creation and all that thing. So we have seen these all 5 scenarios. After this you can watch this video which may be helpful to you. Just watch this video.
Hi, this is Dr. Tutan Ahmed, faculty of Vinod Gupta School of Management, IIT Kharagpur. I don't have any legal background, I am not a law professor, but I will tell you my experience, how I came across the world of intellectual property and how. I did my PhD in public policy from one of the IIMs, and we really didn't need at any point to learn about patent or take it very seriously, how to apply in my work. But after my PhD, I started working in international organizations in Delhi, and while I was working with United Nations in Delhi, I actually started a work which was quite new. We started to work on predicting sort of developing a methodology to predict employment forecast. While I started the work, I was not very like conscious about filing a patent or anything like that, but I started to started to present the work in public domain. I also shared the idea with many other people. After a year or so, we felt that this work could be quite valuable and we may consider protecting the idea. But at that time, neither me nor my supervisor had any sort of idea how we can protect this the work that we are doing. So I I thought of actually talking to the intellectual property office in Delhi. I was based in Delhi, and so one day I actually went there. I discussed with the officer there, and they said since it is a methodology, so it cannot be protected under IP Act, Government of India, but it can be protected under copyright, which is equivalent to publishing a paper. So at that point I thought, well, so why not just publish a paper then? So I started writing the paper, and I also submitted to a journal. Meanwhile, I came to IIT Kharagpur as a faculty. Incidentally, I came across Professor Gauri, who is the instructor of this course. I took one of her workshop where she was explaining the concept of patent, copyright, and intellectual property, and how we can actually use these tools for protecting our work. It was quite insightful. I further discussed my work with her, and I got like quite a lot of insight about how to go about it. So then I presented the work to IPR committee. We have an IPR committee in IIT Kharagpur, and it is halfway through the process of patent filing. Meanwhile, my paper which I submitted also got accepted. So now there is a problem. If you have your paper in the public domain, you cannot really file a patent because there are some conflicts. But with the faculty of IP school, law school here in IIT Kharagpur, I got to figure out like some of the ways how we can really do that. So that was really very helpful. So I think with this experience, I think it is very important for people in academia from different disciplines, even if the intellectual property is not directly relevant to their work, should actually learn about it. There are two reasons to it. First, in general, you never know how your work could actually lead to something very valuable, and at that point, if you don't know about the idea of patent and copyright, you might just lose it. Secondly, it is important for everyone actually to know about patent, because I think in India the awareness on intellectual property is quite low. So students, faculties, as well as common people should know about intellectual property. Students particularly, they are in this phase of this particular time. Students are going for startups, they are thinking of developing products, and when you are developing products or building a startup, it is very important to protect your ideas and works, right? Otherwise, you simply won't be able to encash the value of your work. Faculties, as I just said, even if it is not related to their direct area of work, they should know about it, because it will help to think in a new perspective. And for common people, I feel that in India the awareness about patent is quite low. So it is very important that we should know more about it. Thank you so much.
With this, we come to the end of this session. See you in the next module or next session. Thank you.